very minimal introduction so I don't cut into your time. Gretchen Engel is the director of the Center for Death Penalty Litigation here in Durham, North Carolina. She has been representing people on death row for over 30 years. Henderson Hill is a past director, among many other titles, of the same organization, and the two of them are stalwarts in the battle to end jury discrimination in this state, both in the context of litigating the Racial Justice Act, trying to make Batson meaningful in our courts, training attorneys all over this state. Most people who work in this field, all people I would say in North Carolina at least, and also across the nation, are deeply indebted to your work in blazing the trail and showing us how it's done. So I'll turn it over to the two of you to give this group an overview of the journey that you've all been on in litigating the Racial Justice Act cases, as well as litigating Batson in our courts, where you think we stand today. And I just want to take this opportunity to really honor the work that you and your teams have done over the years. Thank you for your commitment, and thank you so much for being with us today.
Well, thank you, Emily, and it's especially touching for me to be between two people who have been so important as mentors to me. I interned at Ferguson Stein in law school and worked on a voting rights case with Anita. And of course, Henderson is the one who hired me as his special assistant back in 1992. So we do have the task of summarizing nearly 40 years of litigation under the federal Constitution and a now repealed state statute. So we'll just be getting to that really quickly. Luckily, Justice Earle's I guess she saw my notes and she already talked about some of the things, so that'll shorten up my presentation. And it occurred to me when she was talking about the sort of the opportunity to serve on a jury and how meaningful it is to people. I was reminded of a recent piece in the New Yorker that some of you may have read by Jill Lepore, and she was talking about how the Jefferson Davis treason trial, which never happened, right? And so Jefferson Davis was indicted by the first federal grand jury that included black people on it. 6 of the 18 men were black. And at one point there was a jury pool called that never heard the case, but there were 12 black men and 12 white men. And there was a lot of thought that the reason that the trial did not go forward was that the prospect of having this person convicted by a jury with black people on it would have been so inflammatory at that time. But there's a picture of these 24 jurors, and one of the people who's in it is, I believe his name is Albert Royal Brooks, and he was born into slavery in 1817 and at some point was able to purchase the freedom of his wife and children and their future children for $800. And so his wife, Lucy Good, made a cameo of his picture, just him from that photograph, had a photo taken of just his face and made it into a brooch, which according to Jill Lepore, she wore every day of her life. And I think that really does speak to the importance, the idea that jury service is a badge of citizenship. It's just so vital. So what I want to tell you, you already know, North Carolina has an abysmal record in enforcing Batson. Since 1986, North Carolina appellate courts have reviewed on the merits Batson objections that involve a number of jurors in 128 cases. And of those 128, 2 of the cases involve strikes of white jurors by counsel for black defendants. The trial judge very scrupulously, very carefully adjudicated those claims and found, yes, there is a reverse Batson violation here, and that was affirmed on appeal. In 2 of the cases, there were technical violations. So the defense counsel is on the ball sufficiently to raise the objection. The trial judge takes it seriously, finds the prima facie case. The prosecutor is asked to give reasons. But somehow in the in the trial, there's just so much going on that the prosecutor fails to give reasons for all of the jurors to which there was an objection. And the judge doesn't notice, and it ends up they just go on and nothing happens. And so in those two cases, the Court of Appeals said, well, they don't even explicitly say it, but there's no mention of intentional discrimination in those cases, but simply Batson's a 3-step process. You did the steps, you did them wrong, and so happily the defendants got new trials, but those are those technical violations. So of the 128, there's 126 cases that involve strikes of minority jurors, usually African American, where they were reviewed on the merits, and in all those cases, there's only one, State versus Clegg from 2022, which Justice Earls already talked about. And Mr. Clegg had already completed his sentence, right? So he really didn't get any benefit from this finding. As Justice Earls mentioned, North Carolina is also an outlier. Alabama has reversed more than 80 convictions on Batson, more than 30. In Florida, South Carolina, there's at least a dozen, including civil cases. Louisiana, Mississippi, and Arkansas, all at least 10. So, as you might wonder, it's different here. North Carolina exceptionalism, right? We just don't have discrimination in the Great North State. But thankfully, a couple of the people who are here, several of the people who are here, Barbara O'Brien, Catherine Grosso, Ron Wright, and Tammy Chavis have certainly demonstrated to all of us that in capital and non-capital cases, what we see is that black prospective jurors are struck at a rate that it's at least double that of white jurors, and that's consistent over time. It's consistent over geographic units all over the state. And if we look at reasons that have been offered to justify the exclusion of black citizens from juries, I think that confirms for us that there really is a problem. And I'm just going to give you a few examples of those. And these are reasons that were stated in open court, and the courts found no reason to grant relief. Black prospective juror participated in a Black Lives Matter protest. She might have even been in leadership in that organization. A black juror attended North Carolina A&T. For those of you who are from out of state, A&T is a historically black university. The students who participated in the February 1st, 1960 sit-in at Woolworths were A&T students. The Venire member was an attractive black woman. One of the defendants was black, and he was attractive too, and she had an unconventional hairstyle. And finally, just the last example I'll share with you, the prosecutors asking prospective jurors, have you heard anything about this case? And this black man says, well, I heard some people in the jury assembly room talking about the case. Oh, well, what did they say? And he said, well, they mentioned that the two black defendants never should have made it out of the woods. The prosecutor asked, did you notice what race those people were? They were white. How did you feel about that when you heard that? And he said, I quote, I thought they weren't giving much consideration to due process. So when he's later struck, the prosecutor cites this as a reason to strike the juror. So just to be clear about this, the state strikes a black man who expresses discomfort with the idea of two white potential jurors advocating lynching, and there's nothing, no redress, no remedy for that. The questions that are posed to black jurors are also very strong evidence, I think, of racism. Is there anything about the way you were treated as a young black man at the time you were stopped by the police that caused you to feel disrespected? Are you familiar with the musician called Bob Marley, or his son, Ziggy Marley, or even the former emperor of Ethiopia, Haile Selassie? Okay, that's a 2,500-page transcript, and I can assure you that no one else has asked that question other than a black prospective juror. Now, of course, could have asked any number of people if they'd heard of Bob Marley and they would have said, why, yes, I do know about that internationally renowned, world-famous musician, right? And then maybe one of my favorites, would your black friends criticize you if you found this black defendant guilty? That's a 1,400-page transcript, and nobody else is asked about their black friends or their white friends other than this black woman. We even have instances where the prosecutor as much as admits that they struck the person because of race. In the case of Henry White, who was tried capitally and received a life sentence, the defense objected when the prosecutor struck two women. And the prosecutor is asked to explain his reasons, and he begins his explanation. They were two black women. Court of Appeals did not reverse. In another case, the prosecutor was asked to explain the strike of a black woman, and he said, quote, "The victim is a black female. That juror is a black female. I left one black person on the jury already." Trial judge turns to defense counsel. Got anything to say about that? Just note our objection, Your Honor. And the trial continued. It was reversed on other grounds on appeal. The Batson objection was actually not raised. So commenting on this abysmal record, former Chief Justice Beasley in 2020 in the Racial Justice Act case said that the Racial Justice Act was the General Assembly's recognition of Batson's ineffectiveness in this state. Henderson's going to talk to you largely about the RJA. I'm going to, in about 30 seconds, give you the chronology of it, because here we are. It's initially enacted in 2009. These researchers from Michigan State University very quickly got their act together and do a study so that most people on death row were able to file motions by 2010. Racial Justice Act says we're not looking at intentional discrimination. We're looking at patterns over time and in different geographical units. We're going to look at cases in the aggregate. You don't have to prove discrimination in your own case. There was a jury selection aspect of it, also charging and sentencing. So in 2012, there's two hearings that focus on jury discrimination. In between those two hearings, the legislature tries to repeal the RJA. Then Governor Beverly Perdue vetoes that. So then the legislature passes an amendment that says you do have to show discrimination in your own case. You can't just rely on statistical evidence, and we're not interested in hearing about statewide patterns of discrimination. But three more people win in the fall. State appeals, while those appeals are ongoing, there's an election in 2012. The RJA is repealed in 2013. The four people who had won in 2012 lose in 2016. They go back. At that point, the Superior Court says, well, there's no law anymore. It's been repealed, so you're out of luck. That all goes back to the Supreme Court in 2019. Those cases are argued. Luckily, it's a different court from the one that we argued to in 2014 or 15, whenever the heck that was. And in 2020, the court says people who filed properly back in 2010 have a right to continue. The courthouse door cannot be closed. You cannot retroactively apply this repeal to them. And so we then went forward in a case where we had a big hearing in February and March, of which my co-presenter, former boss, really good friend, was a big part of, and he's going to tell you more about it. Up to you now.
Is that a handoff?
Yes.
Good morning. I don't do quick well, and I think I've got 15 minutes or less to talk. We've got some really good preparation given Justice Earle's overview and Gretchen's overview. I'm looking at Kim and Ron and Barb and Catherine, and I'm thinking, well, at least I don't have to talk about p-values and chi-square, r-squares, and e-sensitivity. I look at Liz and I'm thinking, there's plenty of that to go around, but time is precious. And so let's not talk statistics. Although, to have been in Johnson County in February or March, it was a special place to be. And you are all, you've all missed out on an experience. And it wasn't just that Barb made the statistics live, made the product of 7,500 juror questionnaires come to life, and the folks who have been subjected to disparate treatment. You felt it through the statistics. Now, Barb had some help. And I'm not talking about the MSU study, Catherine. I'm talking about the hearing. The help was true to the RJA calling. This was an answer to the McGleskey challenge that said, not only are we going to invite science into the criminal justice system, we're just going to open the doors to the church. We're going to open the doors to the courtroom. And whether it's science and statistics or history, that weighs on whether or not African Americans are treated disparately in jury selection. And it was a special place to be in Johnson County in February and March. Black folks came out the woodwork, sort of. The NAACP statewide, Harnett County, Lee County, Johnson County, all of the leadership was there. The members of those organizations were there. Johnson County is still a pretty frightening, intimidating place if you're black. Fortunately, WRAL live streamed it, so those Johnstonians who felt just a little bit otherwise about going into the courtroom followed it closely every day. And what did they hear? In addition, it's kind of funny. You had two sides of it. You had lawyers who were listening to the MSU presentation and thinking it's been challenged. We've had this study for now 14 years. I can't even do that math right. But if you think that in 2012 there was a hearing based on a study that was done at least in 2010 or 2011 and all of that, I've been sort of around Barb and Catherine as databases have been added to, things have been added and subtracted. It's been challenged in court, it's been challenged and reviewed by peers. And so what we had in the spring was a database, a data set that had been reviewed and challenged by legal adversaries, by professional peers, and it withstood all of that, and it got even better. With each revision, the data set was that much more robust. I think, and I bow to my colleagues, as wonderful as Barb and Catherine was, a decision was made, we need to find even more support. And we retained two experts who, did not come from that tradition. When Barb and Catherine started this, they did, the project design, the study design, consulted with George Woodward, consulted with statisticians, and came up with this design. Our experts, to include Richard Smith from UNC, an Oxford-trained mathematician, brilliant guy. So central casting about the height of a leprechaun, real charming guy. Nandita Mitra from the University of Pennsylvania, a biostatistician, a statistician, just one of the national leaders on causal inference. And if you're not a statistician, that may not mean much to you. But in that courtroom, when the challenge was, well, is this just numbers, or do they imply that there's a connection between race and strikes that's causal? Well, this particular expertise, which is relatively recent, has been doing just that in housing, in bio statistics, in public health. That's what they do. They make the connections between these statistical association and causation. This was not part of the earlier presentation, so that when Judge Sermons, who's a judge from Little Washington, with a lot of experience in medical malpractice. So he's used to, quickly absorbing complicated evidence and processing that and then moving on. Well, he was treated because he had our MSU researchers. We had Nandita Mitra, who's a gifted, a God-blessed teacher. And for a bunch of academics I can see in the room, what a blessed teacher is. This is a person that can talk to an intelligent, but not necessarily steeped student and bring that person along. Well, that's what Professor Mitra and Professor Smith did. And they walked us through all of that complicated science. Even I am tempted to go into p-values and try and chi-squares and such. Mostly because there is a point in cross-examination that as a trial lawyer you have to love. Where the government's expert, claimed that a 0.05 p-value was no longer reliable, shouldn't be relied on, and that the society was moving to 0.005 as a standard as the standard. And I just sort of quick get to the chase, And she was asked, in her many years and many studies, what did she rely on? What standard did she rely on? And she said, well, the better standard is 0.005. Well, what did you rely on? What reports did you file, and under what standard were those reports and studies written? Well, you have to get it published, and to get it published, you have to use 0.05. She had hundreds of these studies, and most of them she didn't get paid for those studies, part of her academic work. Well, had you ever written anything that said that 0.05 was unreliable? No. If this is the first time, yes. Are you getting paid for your testimony here? Yes. What about your use of the 0.05 statistics? At the point that Jay was asking this question, co-counsel Cassie Stubbs put a banker's box of studies. Said, all these studies that you've published and written, 300 out of them, what standard did they use? 0.05. Her comeback, I was second or third author on those studies. If I'm second or third author, I just sign it without reading. There's a whole seminar on that, so I have to sort of leave that alone, just to let you know that was a kind of drama we had in this courtroom. And think about it. We've been talking about drama in the context of statistics. Don't you know that we have 3 expert historians? And they were not chump change. I mean, there was a PhD student who wrote his dissertation on the lethal state, the death penalty in North Carolina. He wrote a really respected law review article, co-written with Duke's own at the time, Robert Mosteller, on the RJA. This is a guy whose whole professional development has been centered on North Carolina's death penalty. Not bad. So when we're talking about whether or not burglary and rape in the pre-Furman age was the past in which black folks got disparately the death penalty, he had all the statistics. He had the connection. Black man charged with rape is a capital crime. That's because black man charged with burglary is a capital charge. And that's because burglary implied that he was interested in going into the house because there was a white woman in that house, and that white woman had to be protected. Just amazing stuff to come from him. Another expert was Brian Stevenson. Have you heard that name? I mean, if you've been in Brian's presence and you've heard him talk and give these stories, it's so damn compelling. Well, just imagine on a witness stand, he's being asked legal questions. That same amazing creativity and passion, his understated passion came through. I mean, when he tracked the history in North Carolina, 14 peremptories is what the defendant got for most of the 20th century. And the state got 6. Well, that was fine when black people weren't on the jury because black people did get in. Yeah, in Speller in 1948, it was known 60% of Bertie County is black. The clerk says he never heard of a black person getting on the jury, but they found nothing discriminatory in that. That was North Carolina. In Cofield in 1987, when in Northampton County, trying to decide, well, why is it in this largely black county we just can't find black grand jurors? Well, could it be that there were red ballot sheets and blue ballot sheets, and the blue ballots were white folks and the red was black? And so it's not discrimination, it's just the sheriff took names from that color-coded sheet. Oh, and there were no black people on those sheets. This is the North Carolina that we're talking about. So when Little Danny Pilot does his 30-year review of Batson in North Carolina, it shouldn't be a surprise that until Clegg, there was no Batson findings for a African American. So here we are. We've been trying to describe the excitement that you guys missed because you weren't in Johnson County, and I buried the lead because what you missed was Professor Crystal Sanders,
Who went here too?
a product of Duke, a Duke history professor, Duke history major, and a professor at Emory. History professor at Emory. But more to the point, she was the valedictorian of Clayton High School in Johnson County. Her father was in the first class of post-Brown admission in integrated schools in Johnson County in 1969. Bore the brunt of that discrimination. In Johnson County, when you came into Johnson County to Smithfield from Clayton, you were welcomed by this huge billboard just as you're crossing the Neuse River. Welcome to Smithfield, KKK country. If you were coming in from Selma to the east, same sign or a similar sign. If you're coming in from Clayton and you're going to the courthouse is just 3 blocks away from that sign. Don't you know if you're a juror responding to a summons, you saw that sign and you took the meaning of that sign? So when Crystal Sanders took the stand, she brought not only her history and her father's history, but she traces her ancestry to the slave plantations in Johnson County. 1867 is when the First Baptist Church of Smithfield was founded. That's her. That was black church. History is written on her skin. It's written in her soul. The funny thing is, when we started this hearing, the judge looked and said, "Well, we got three statisticians and 3 history experts. The only one that really got a pass was Sam Summers, because there was only 1 of them. And so his social science thing came in as it should have been, just eaten up. I mean, when he talked about the implicit association test, when he talked about unbiased, unconscious discrimination, you got a sense, this is why the General Assembly passed the Racial Justice Act without a need to prove intentional discrimination. When he discussed those behavioral studies, those social science studies, some in the context of jury selection, experimental studies where you control each of the factors, and some in mock study, just a range of different studies. Converging validity. That's what he talked about as a research methodology expert. What he saw out of the studies from MSU, the experimental studies, the reviews by our causal experts, they were all coming together, and they all came together with the history evidence that we present. Well, time's up. I'll just say a word that one thing that was left out, which was a real indictment of the state, are the notes, the prosecutor notes. And I think there's some description of it in some of the paper. Is it in your paper? Well, there's some description, the descriptions of what's contained in those prosecutor notes of jury selection. It put me in mind of the Access Hollywood tape. When
Wow.
it's easy for me to go there.
Yeah.
Yeah, when Melania says, "Oh, that's just locker room talk," you got that feeling when you're reading these notes one after another, and they're talking, be here, big brute, all of these race-sensitive descriptions that are in these prosecutor notes. You're thinking, why are they so preoccupied with race? That's what the notes suggest. Just a complete preoccupation with race. And the question is that just sort of white guy talk? Because it's race and it's women. I mean, you got to close your eyes to some of the descriptions of the women. Big breasted, this one over here, and